Okay, all right. I hope everybody has had a good lunch. We're now on to issues related to the law of the sea and environmental law. I'm happy to say I have an excellently qualified panel with me. I'm only here to keep time and to look for questions afterwards. So without further ado, let me give the floor to Professor Elisa Morgera, who is from Strathclyde University, and she will be speaking to us about mutual supportive interpretation of the law of the sea, international biodiversity law, and human rights. So that's a nice broad title. We're looking forward to that, Elisa.
Thank you so much. Yeah, it's a pleasure to be here, and I've really enjoyed the discussions in the morning. I realized maybe I should start with a caveat of where I'm coming from in terms of a practice of interpretation. I spent the last 4 years working and mediating with deep sea ecologists, fisheries scientists, sociologists, environmental justice scholar activists, and somehow we were all brought together by the law. So international law, and particularly the relationship between international human rights law and the law of the sea, where the frame which brought us together into a broader research program, which is actually funded by development cooperation budget of the UK government. So it's research for sustainable development among scholars in the global north and the global south. And I've learned a lot from my colleagues in terms of how, well, I've been challenged, I think, a lot from my colleagues about whether and how international law is really there to respond to the everyday challenges they face, either in having the science understood in decision-making processes about the global environmental crisis that are affecting us all, and understanding also how those environmental crises are affecting some groups and individuals more than others, particularly in the global south. And so the title of my presentation is really about looking at interpretation of international law also as a way to clarify a path towards transformative change. And the idea of transformative change actually comes from two global science assessments on the part of the Intergovernmental Panel on Climate Change and the sister panel on biodiversity and ecosystem services. And it was really on the back of understanding the gravity and urgency of the intertwined global environmental crisis of climate change, biodiversity loss, and toxic pollution, and the understanding of how that combination is undermining the realization of 80% of the SDG targets. So it really affects a whole plethora of human aspects of human well-being, and in fact, our own survival on Earth. And so the notion of transformative change is in a way a test to see whether existing international law is up to that challenge. And I think the interpretation of international law in light of that scientific evidence is a way to maybe realize the potential for international law to contribute to transformative change, or it can be, of course, used to prevent international law from playing that role. And so just to give a bit of a definition to transformative change, I'm relying particularly on what the Intergovernmental Panel on Biodiversity and Ecosystem Services has defined, and as a fundamental system-wide change. So it's really applying system thinking as opposed to, as we all know, thinking in silos, but really looking at changes in paradigms and values. And so what that requires is not just looking at the immediate cause of those environmental crises, but the underlying power relations, vested interest, unequal distribution of cost and benefits, and tendencies to short-term decision-making, which eventually are also compounded with lack of policy coherence. And I think the point about coherence has come up in our earlier conversation, and it's a crucial role for interpretation. So to my mind, all these issues are issues that the law can and has addressed. In particular, international human rights law might have been the branch of international law that has dealt with problems of power imbalances the most. And coming from an international environmental law perspective, what I've been interested in is to see to what extent we can read the law of the sea provisions on the protection of the marine environment in the light of international human rights law, and particularly the more recent understanding of how international human rights law is interdependent from international biodiversity law. Many of you in the room will be familiar that our understanding of the interlinkages between climate change and human rights is really advanced, but I think the understanding of where international biodiversity law stands, even if it is very much connected also with making progress on climate change mitigation and adaptation, and how it relates to human rights is a bit less widely understood and engaged with in the doctrine and international jurisprudence. So just to take us through a path in a gradual way, I guess the first point is that many international lawyers and adjudicators have engaged with reading the Law of the Sea and the Convention on the Law of the Sea in particular, together with international biodiversity law. The Law of the Sea Convention has broad terms for its provisions on the protection of the marine environment. And while it doesn't mention biodiversity as such, it does mention ecosystems, and it is framed in a way that was very much conducive to an evolutive and systemic interpretation with international biodiversity law. To the point that now the most recent textbooks on international law of the sea clearly have a whole section on the protection of marine biodiversity and discuss the reading of the two treaties of the Convention on the Law of the Sea and the CBD in relatively settled terms. Although what I would argue, without going into too much detail, is that maybe that understanding of how these two areas of international law are read together is to some extent limited. And I think the Convention on Biological Diversity has been relied upon almost as a dictionary to provide clarification on key terms and understanding of certain objects of protection of international law. So the more complex understanding of the interdependency of life on Earth that the term biodiversity and ecosystems convey. But there has been more reticence to interpret the provisions in the convention itself in deeper ways. And I think we have seen, for instance, also potentially a comparable reticence by the International Court of Justice to see whether certain provisions of the CBD, such as those on environmental impact assessments, are in fact even legally binding. And so I think one of the conundrums, one of the limitations in the mutually supportive interpretation of the Law of the Sea and the Convention on Biological Diversity is certainly a question of interpretation, whether or not the treaty text of the CBD itself in fact contains legally binding obligations, or whether because of the open-ended terms it uses, it's actually of a soft law nature. And that's been discussed in the literature as well. There's also another ongoing challenge in this debate, which has to do whether or not the Convention on Biological Diversity applies to areas beyond national jurisdiction. This I find quite a politically charged debate, although to my mind, the letter of the relevant article in the Convention on the Law of the Sea, referring to processes and activities in areas beyond national jurisdiction, is to me quite broad and allows for almost any activity the states may be held accountable for to fall also under the Convention on Biological Diversity. But that has not been, I think, the interpretation that I've heard very often in relevant international negotiations and debates. And I think what has been maybe missed so far, both in international lawmaking processes and potentially also in arguments brought before international tribunals to a latter extent, is that beyond the text of the convention, we have had a very significant normative activity by the Conference of the Parties to the CBD, and very significant interpretative development, I would say, of the content of the convention, reaching consensus among 196 states, often with very significant contributions also from indigenous people representatives and other experts. And so there's a whole body of intergovernmentally approved interpretative guidance under the Convention on Biological Diversity that provides a lot of clarity on the ways in which the convention can apply in very specific circumstances, including fisheries, including ocean-based climate action, etc. And this has been picked up by, for instance, the Inter-American Court of Human Rights, really very much recognizing how CBD guidelines are intergovernmentally approved interpretations that contribute to clarifying the legally binding content of the American Convention on Human Rights. So the court has really engaged and made use of that body of interpretation that states have agreed among themselves to then interpret and clarify the obligations of states under another treaty. And I think through that, confirming that for those states who are party to the American Convention, certain CBD obligations are also binding in that intertwined reading with the American system of protection of human rights. But maybe to my mind, there's an even deeper argument, which we move beyond, particularly the protection of indigenous people's human rights, which is the area in which the Inter-American Court has the most engaged with the interpretation of the CBD. And this is really the promise of the ecosystem approach as identified and spelled out by the parties under the CBD to provide a normative concept for that system thinking and kind of the normative corresponding to the indivisibility of human rights. It really calls for the understanding of how we need to take into account all the interlinkages between life from the ecosystem level to the genetic level in any ecosystem, from marine to terrestrial to freshwater. And I think that maybe has been so far an area where more could be done of the CBD and its guidance to protect everyone's human rights, not just indigenous people's human rights, even if there's still much more to be done there. So where this has become a bit clearer has been in the work of the former UN Special Rapporteur on Human Rights and the Environment. I think John Knox, with his first report on biodiversity and human rights, has really read, to my knowledge, for the first time in an authoritative piece, although we can discuss to what extent it is considered authoritative, the obligation of the Convention on Biological Diversity through the lens of international human rights law, and has really confirmed that whereas CBD states often argue that they do not have binding obligations under the convention in certain instances, or they have a very wide margin of discretion, which I think is an accurate reading of the flexibility in language of the convention, that wide margin of discretion is limited to the extent that non-compliance with the CBD leads to foreseeable infringements of human rights. And I think this really inserts into the more common understanding of the CBD a really significant limitation in terms of both status and content, minimum content of the obligations under that convention. Once again, I think that understanding is best encapsulated in relation to the relevance of protection of biodiversity for the protection of indigenous people's rights. But I think little by little, we're seeing how this is becoming clearer for the protection of children's rights in the recent draft General Comment 26 that the UN Committee on the Rights of Children released only 2 weeks ago, the protection of the rights of women, protection of rights of peasants, and I would say the protection of everyone's right to a healthy environment, which has been recognized by the UN General Assembly. But the question, again, of its content remains, I think, open among states. So what I would like to say, maybe moving forward, is that maybe what is most interesting for me is that those recent legal understanding of the relevance of the Convention on Biological Diversity for a broader range of human rights than indigenous people's rights is very much aligned and in fact catching up with global scientific assessments, and particularly I think medical evidence around the many ways in which our physical and mental well-being are dependent on a healthy and biodiverse environment, from the times of recuperation from an operation to transmissible diseases to hereditary diseases, even from our own well-being in terms of our own microbiome and how that is always in conversation with the microbes around us. I mean, the medical evidence is just so illuminated of all the ways in which our own well-being from every day to the long term is essentially based on biodiversity. And the fact that we are failing to protect biodiversity quite spectacularly is really, as I was saying, and as has been captured by the IPBS, raising, I think, fundamental questions, beyond legal interpretation, but about the effectiveness of our international commitments under the CBD. And I think looking at the broader range of efforts in terms of environmental protection, our efforts at sea are lagging behind compared to our efforts at land, partly And I think importantly, because our knowledge of the sea is lagging behind compared to our knowledge of land. And it's often said, and I think it's very true, that we know more about outer space than we know about the ocean. We don't even know the full morphological conditions of the seabed, let alone everything about the life in the ocean and how that life is essential for our own life and well-being on Earth, from half of the oxygen we breathe to how we discover new medicines, or for instance, how was discovered one of the tests for identifying the COVID virus. And so the point is then, if I try to bring all of this together, I mean, we know that the CBD and the Law of the Sea can be read together, although that can be done in a more advanced way, maybe that has been done so far. And if you bring also that more recent legal understanding of how the Convention on Biological Diversity relate to the protection of human rights, the question is, well, can we read all of three together? And what can that mean for understanding the provisions on the protection of the marine environment in a transformative way? And to me, the opportunity is there in that both human rights and that understanding of how human rights relate to biodiversity very much speak to the major equity issues that have not allowed maybe the international community to advance as much as it wanted in effectively protecting the marine environment, and for all states around the world to advance ocean science in a way that can improve everyone's efforts to protect the marine environment. And so I'm really, at this point, sharing an argument I'm developing, maybe as a self-confessed norm entrepreneur, but also as a colleague working not only with, I think, small-scale fishers and NGOs on the ground, but also with different UN bodies who are interested in seeing advanced compliance with the Law of the Sea, with human rights, and with biodiversity law. And so that's been conversations with the Office of the High Commissioner for Human Rights, FAO, UNEP, and the Special Rapporteurs and others. And so my proposal is, well, it is possible, for instance, to interpret two aspects of equity under the Law of the Sea in light of that interface between biodiversity and human rights. And on the one hand, we could look at intra-generational equity and filling that with content in a similar way in which, say, John Knox has understood and the Inter-American Court have understood protection of indigenous people's rights under the CBD, by looking at the human right to science. So the human right to science is not necessarily the most well-known human right, although it was there all along in the Universal Declaration, and is a legally binding right under the Covenant on Economic, Social, and Cultural Rights. But what I think it does is really clarifying that the area of advancing science, scientific cooperation, the importance of science for environmental protection, which are all things that are addressed to some extent under the Convention of the Law of the Sea, but are often seen as unclear in content, unclear in margin of discretion for states. Often they're even seen as potentially non-legally binding. The minimum content of obligations, I think, becomes clearer, and that system thinking that states need to engage with to fully comply with the convention becomes clearer once we take into account the interpretative guidance that has been provided on the human right to science, which is really about taking those power imbalances into account and therefore looking at what could be triggering a more transformative approach to the protection of the marine environment. So the UN Special Rapporteur on Cultural Rights in 2011 spelled out 4 dimensions of the human right to science: the right for everyone to access the benefits of science without discrimination. Thank you. The opportunity for all to contribute to scientific research, protecting everybody against negative consequences of scientific research, and the obligation to ensure priorities for scientific research that focus on the needs of the most vulnerable. Now, if we take these indications in the context of the provisions in the Law of the Sea on marine scientific research and cooperation, but also in the context of provisions on capacity building and technology transfer, we see a whole set of maybe more defined directions and maybe limits to state conduct in really fostering that cooperation and directing it to specific needs that cut across the protection of the marine environment, but also the protection of basic human rights. Of course, the situation in which we are at in terms of where we discuss the protection of the marine environment is quite far from that deep engagement with human rights and the systemic understanding of the issues at stake. But I think this is just an argument to show that we can read the law of the sea in this slide and think about where state conduct can take a different direction, or maybe ongoing international lawmaking processes, such as one on a new international instrument on marine biodiversity of areas beyond jurisdiction, could encapsulate that more advanced reading of international law. And the final point, which I'll make in 1 minute, I promise, is that the other, I think, key aspect is intergenerational equity, which is another element that usually both in international environmental law and the law of the sea remains undefined. And I think the Convention on the Rights of the Child does provide for a vast majority of states legally binding standards about what intergenerational equity means for the new generations that come on this planet basically every day. And what I found most interesting looking at the draft general comment that has been shared is, first of all, there's a direct connection between marine pollution and the protection of children's rights, which, to be honest, was hard thought. It wasn't quite in the minds of the committee a few months ago, but I'm happy it's there now. But most significant, I think, in terms of how we read the law of the sea in a way to really respond to UNCLOS states who are members of the Convention on the Rights of the Child obligations, is the notion of time, and how that notion of time from the perspective of children's rights gives much more specific and ambitious understanding of precaution and the due diligence under the law of the sea. And maybe I'll stop there.
Thank you very much. And I'm sorry that as a timekeeper, I make you trip over these words like intergenerational. Anyway, without further ado, I'm happy to pass the floor to Dr. Ilias Plakokefalos, if I get
Excellent.
that right, who is going to talk to us a bit about environmental law issues.
Right. Thank you so much. Thank you, Panos. Thank you, Sotiris, for inviting me. It's a pleasure, really, and an honor. I have to admit, before I begin with my presentation, that I try to engage a little bit with the literature of the project and what Panos especially has written. My Greek is not good enough to read your papers in English. That's all I have to say. Okay, so moving on. I was called upon to present a paper on the interpretation of customary international environmental law, and it made me think that the way to go ahead with that project is first to identify the peculiarities of international environmental law and its relationship with custom. Then I will discuss a little bit about the customary international law, international environmental law rules as applied by the International Court of Justice mainly. I will only look at two of them. And in the end, I will ask a couple of questions to myself and to you regarding the notion of interpreting custom, at least in the context of environmental law. So first things first, the peculiar nature and case of international environmental law. I realize that everybody, you're doing human rights, you think that human rights are the most peculiar area of international law. If you're doing, trade law and so on and so forth. It is true for all of these branches of international law. Now, environmental law is a treaty-based law. We have, depending on how you count, between 3,000, 5,000 international environmental law treaties, bilateral, multilateral, and so on and so forth. So at first, and it makes sense, right? It's a technical branch. There's a lot of science involved. Maybe we could use some more, but there's a lot of science involved. There are instruments that build for what is called autonomous institutional arrangements within them, like treaty bodies that further develop the content of the treaty, and they issue regulations, recommendations, technical reports. There's a lot of written word in international environmental law. Besides treaties, there are at least two fundamental documents of a declaratory nature, the Stockholm Declaration and the Rio Declaration, that contain principles as opposed to rules of international environmental law. Now, Some of these principles are clearly customary in nature, the prevention principle. Some of them are debatable. The precautionary principle approach, you name it, sustainable development has also been hotly debated whether it is a rule, is it a concept, as the International Court of Justice said, is it something else, is it an interstitial norm, as Von Lowe has said. So this is a mixed bag of these principles as to their normative pull and value. There is also a heavy influence of the International Law Commission, the project on the prevention of transboundary harm and the articles on the prevention of transboundary harm and the principles on the allocation of loss of the ILC have, at least to my mind, at least the articles on prevention have crystallized many the content of the obligation to prevent transboundary harm. And it has done so by breaking down the obligation to prevent to further obligations of result, like to negotiate, to consult, to conduct an environmental impact assessment, to notify, and so on and so forth. The second point is that despite this wealth of documents, there is no overarching convention. There is no such thing as the Law of the Sea Convention. There is no such thing as the ICCPR. There's nothing of the sort. Meaning that we have a lot of rules in different places with different normative value and no underlying document. At the same time, it also means that there is no specialized court like the European Court of Human Rights or Ilias or WTO panels. There is no specialized court, meaning that very often it falls upon courts that are parts of different conventions to interpret and apply international environmental treaty law. There is an inherent bias there, I suppose. The courts are usually called to have jurisdiction to interpret their own convention, right? And they use, for lack of a better word, international environmental law incidentally. So there's no development by the International Court of Justice had actually a chamber on international environmental law. No one visited. So it was essentially defunct. The lack of an overarching international environmental law convention essentially means that customary international environmental law has a lot of value because it is there that we're going to look for guidance in the big questions and the fundamental notions of international environmental law, meaning that it is important. It looks marginalized because of the sheer number of treaty, of treaty instruments, but in fact, it is that lack, sort of balances the situation quite a lot. So this is the setting. The next question is how the courts have identified and applied customary international environmental law. I will just focus on the no harm obligation, the prevention obligation, and the obligation to conduct an environmental impact assessment, as these two have been the two that have been discussed most by courts. Famously and ironically enough, the first proclamation on the no harm obligation has been in the Trail Smelter case, ironically because the tribunal there drew an analogy from US intrastate law and said that by analogy, there is this no harm obligation in international environmental law. And it's interesting, maybe a different paper, how this became the standard, how everybody thought that it was a good idea, even though there was no legal basis for that proclamation whatsoever in international law. Then the ICJ, of course, in the Corfu Channel case, repeated that idea, not based on the environment, but still. And we had to go well into the 90s to hear a word from the ICJ and the nuclear weapons advisory opinion is the first, clear proclamation of such a rule, which is repeated in the pulp mills case. And there is where the problems begin. the court in the pulp mills did say that there is a no harm rule in international environmental law. It repeated the Corfu Challenge, it repeated the nuclear weapons dicta, but it did not define the content of the rule. It said nothing. It made things worse by saying that the rule has a substantive and a procedural element, and there is a functional link between them, and it stopped. It didn't explain what is this functional link and what it means. So there's that. And this was heavily criticized in the dissenting opinion of Judges Sygna and Alpasaner on that case. So it was picked up by members of the court as well. It was not as if that was accepted as a normal statement. Now, and it is not as if the parties before the court did not claim to identify the content of the rule. There was material before the court. There has been, the LC had already finished its work. There's a wealth of conventions, and the court didn't pay attention to that. They did the exact same thing in Costa Rica, Nicaragua, Costa Rica. I will say Costa Rica, Nicaragua throughout the presentation, right? You know what I mean, these two cases. And the feeling that one is left with is that there's no elaboration. There's nothing, almost a denial to look into the details of the no harm rule, whereas we know that there is material to look into. When it comes to the environmental impact assessment obligation, again, the ICJ and the pulp mills took a position, an approach rather, that was not very satisfactory. It stated that the EIA is customary law obligation, an obligation in general international law. And it said that the content of the obligation and how a state goes about conducting an environmental impact assessment is to be determined by the law of that state. Whereas again, you know, that obligation is ubiquitous in international environmental law. It's everywhere with different formulations, more stringent, more lenient. We have the ESPU Convention that sets out detailed guidelines as to rules, rather, how to conduct an environmental impact assessment. I mean, if you want to look and find, you can. And again, it didn't stop there. While it said that it is upon the law of the state on how to conduct the environmental impact assessment, it went on to question that. Question how or why in that case, which model did it use in order to assess the status of the river, and compared it to what Argentina used, what model in order to determine the impact on the river. And without consulting anyone, no expert witnesses, no nothing. It said it is upon the court to decide, and we think that Uruguay did well. Again, heavily criticized, both in the literature and in the dissenting opinions in the court. It did a little bit better in Costa Rica, Nicaragua, where finally, without telling us where this notion came from, it said, okay, like we said in pulp mills, it is an obligation of customary nature, and we have to take account the location of the project, the geographical conditions, the scale of the project. So there, finally, we have something that looks like that the court looks like giving content to that rule. So this is the state of play of customary international law with these two obligations before the International Court of Justice. Now to the question. We know that this was a conservative approach, and at times it was not conservative because it didn't follow, you know, the latest developments, but also because it lagged behind the actual status of international environmental law at the time, or even years before. How can we look at it? We can look at it through one lens that says, okay, there is a proclamation of the rule. I identify that there is a rule of customary international law. And then I identify its content. If you look at it this way, there's no interpretation to be had. It's just to tell you that there is an obligation to conduct an environmental impact assessment. And the content of that rule is that you have to take into account the location, the scale, and so on and so forth. And then you apply the rule to the facts, as we learned in law school, right? There's a different way to look at the structure that might accommodate the notion of interpreting custom. Two different ways, rather. One is to say that actually the identification of the content is itself interpretation of the rule. I don't know what are going to be the standards of that interpretation, what are going to be the limits of that interpretation. It is difficult in my mind to think of customary law as involving notions like object and purpose, intent of the parties. Evolutive interpretation probably does not exist because it is the evolution of custom itself. The practice evolves, therefore you have a new customary rule or a new version of it. But still, it can be looked as interpretation. The other point in this two-step approach, identification of the rule as custom, and then identification of the content, is to insert or think of having or of it being there a little step before the application, where the court might look at details, portions of the rule that are not exactly state practice. They cannot be seen either as subsequent practice or subsequent agreement, but they are there in the wild, so to speak. Elisa was talking about recommendations of the committees and of the conventions. There's a wealth of material that you can look and really fine-tune the content of the rule. And this is the point that to me looks more promising as calling it interpretation. So you have form, content, and then fine-tuning through interpretation by looking at what the states themselves have accepted as standards. Remember, we're talking about, again, a technical field of law, right? We can have eco standards that you can bring in the customary, the customary nature of the rule without referring to one particular treaty. The court does it anyway. It did it in pulp mills. It looked at different eco standards developed by different agencies or different international organizations. These things are happening when we look at treaties. They may well happen if we look at custom and look at the widest possible, more widely rather accepted standards. And by the way, I haven't given an answer. I'm still asking and waiting to see how this goes. Thank you so much. I'll stop.
Thank you. You got me worried there. I haven't yet given an answer, so I thought you would.
No, I'm not going to give an answer.
Okay, so that's.
I asked questions.
That's for the debate.
Yeah.
Okay, so the next person to raise questions and do a presentation about issues related to the law of the sea is my left-hand neighbor, Professor Jean-Marc Thouvenin, who is a professor of international law, I suspect, at the University of Paris-Ouest, Nanterre-La Défense, but also he's the Secretary General of the Hague Academy of International Law, which is essentially just that way round the corner. With no further introductions, I'm happy to give you the floor.
Thank you, Ms. Chairman. Thank you very much for the invitation to say some words at this conference on a very difficult question. I will focus on customary international indeed, and my topic is mainly to see what practice has to do with interpretation of customary international law. Well, very simplistically, I would say that begin with, there are different ways of understanding what is customary international law, what it is really. Under one approach, which is, I think, inspired by Italian doctrine, custom is made of rules arising spontaneously from the social needs. It has no relation with states' will or any sort of consent. It exists as the outcome of a sort of social consensusness. And not of it's not the outcome of a legal process, really. It's a reality that is social. In this regard, practice and opinion juris are nothing more than proofs, as is written in Article 38 of the Statute of the Court of the ICJ, proofs of the existence of the rule, not a process of creation of the rule. Under another approach, customary international is rather based on sovereign will, although tacitly expressed. We know it's very much criticized, but this is a tendency that still keeps on inspiring some approach. And of course, we have the basic position of the PCIJ in 1927 in the Lotus case, which says that. So if one looks at the law of the sea, it mainly, in my view, appears as made of compromises between different interests and seems hardly derived from social consensusness. Most of the rules of the law of the sea are the outcome of an equilibrium between different interests or opposing claims. There is a basic tension between what we call in French, I don't know the translation, I'm sorry, I will say it in French, but I don't know in Greek, which is the les États du large, so the states which are interested by navigating around the world, et les États côtiers, les États, the coastal states. So there is this tension between these two broadly described interests. And the evolutive equilibrium of the law of the sea, and we know there is a story behind, is the outcome, the resulting outcome of these tensions, and the equilibrium makes the current rules. There are perhaps in the law of the sea other kinds of opposing interests at play, but also sometimes some values. And here we have probably what touch upon environmental law of the sea, which is not so much linked to an equilibrium between different interests, even if, of course, there are some kind of tensions here as well, but it's more arguably the outcome of a social need, the protection of the marine environment for different reasons we know. Well, what does it matter? Why, sorry, does it matter? When it comes to the interpretation of customary international law? Well, it seems to me that depending of the nature of the rule, is its raison d'être, its interpretation can respond to different techniques, to different concepts, to different philosophy. If the raison d'être of the rule is to reflect a compromise between opposing interests, crystallize the equilibrium between opposing claims, its interpretation will rather, to my mind, seek to clarify what is exactly the compromise. That will be the focus. And the focus will be on understanding what were the claims at play, what were the dynamics leading to the emergence of the rule around an equilibrium or a compromise. And under such approach, if accepted, the practice of states is arguably key to the interpretation of the rule even once it exists, insofar as this practice is generalized, of course, and is accepted or generally accepted. In other words, what we call, when it comes to the law of treaties, subsequent practice of states is relevant when it comes to the interpretation of the customary international rule already existing. And here we have, of course, a feature which is, as I said, also of use, or perhaps should be of use when it comes to the interpretation of treaties. I don't talk about the European Union treaties, of course, because state practice is not relevant. But I'm talking about more broadly, for example, the UNCLOS. And in this regard, I should say that the interpretation of Article 121, paragraph 3 of the UNCLOS by the South China Sea Tribunal, you may recall it has been hugely criticized precisely because it did not take any account of state practice of this article and ended up with an interpretation which is at odds with the state practice. So that has been queried, and I think it has been criticized rightly. But this is treaty interpretation. My point here is that when it comes to the customary international law and where an established rule must be interpreted, there is no way in escaping state practice when it comes, of course, to interpreting a rule, crystallizing an equilibrium, as I said before. Of course, state practice is relevant. It is, if it is, I would say, massive or general, and if it is generally accepted. And of course, this leads us to take a look at the 2022 judgment of the ICJ in the alleged violations of sovereign rights and maritime spaces in the Caribbean Sea, which is very interesting in this regard. In this case, the court was confronted to the question of what are the powers that coastal states can exercise in their contiguous zone. So the court said, of course, that Article 33 of UNCLOS on contiguous zone reflects customary international law, and this provision does not mention that coastal states have the power to exercise control with respect to the security. So they have some powers, there is a list of items in which they can exercise their power, but there is nothing like security. So the court observed that the text does not contain this notion. Then the court observed that there is some state practice regarding the inclusion of a notion of security in their powers exercised in their contiguous zone, but this practice has been opposed by others. There has been protest. So according to the court, in this case, state practice did not prove anything different from what the text of Article 33 says. Well, of course, here, and that's what you perhaps suggested, the question was not really about interpretation of the text. It was whether the text had been completed by a subsequent rule born out of state practice. But it's interesting anyway to look at how state practice is taken into account or rejected by the ICJ here. Of course, the court also discussed in 2022 whether a coastal state is entitled to extend the breadth of its contiguous zone beyond 24 nautical miles. This is a rule we know, 24 miles. And Colombia was claiming, well, we can extend a little bit the breadth of the contiguous zone in order to clarify the lines, because of course, sometimes when you project the 24 nautical miles from the baselines, you have lines which are very, circumvoluted, and it's difficult to follow. So Colombia was saying, well, let me do something more clear, even if it goes beyond 24 nautical miles. So here the court had to interpret the rule, whether it can be applied flexibly or subject to some sort of minimal exceptions, or should be implemented strictly. And the court said, well, there is no flexible interpretation of this rule, because should the contiguous zone expand beyond 24 nautical miles, it would be to the detriment of the exercise by Nicaragua, in this case, of its sovereign rights and jurisdiction in the EEZ. So here we find an interesting illustration of the interpretation of a customary international rule, taking into account and rejecting the subsequent state practice, which was very few and contested, but also focusing on the qui pro quo, if I may say, which initiated the rule. Of course, it's very difficult to expand the interpretation of what the court says here, because it was a question of overlap between the expansion of the contiguous zone and the EEZ of another state, which is a very rare situation. Normally, the contiguous zone is in your own EEZ, not in the EEZ of another state. So that was quite special, but at the same time, I think interesting. And the court also interpreted, and perhaps it's the most interesting point, the term sanitary in Article 33 of UNCLOS as crystallizing customary international law. And of course, Colombia was saying, well, sanitary must be or can be interpreted as encompassing environmental concern, because of course the environment triggers the quality of life, and so this is sanitary-like. The court denied this interpretation, this broad interpretation of the term sanitary, on three arguments, interesting three arguments. First, marine environment is governed separately by customary international law on the environment. So that might be said an approach of interpretation which is systemic, looking at the overall, the overall system and say, well, it's dealt with somewhere else, and so it should not be addressed here. Second argument, the terms were originally included in Article 33 when it was written in connection with custom regulation, which has nothing to do with environmental, marine environmental concern. So here appears an interpretation based on the initial compromise. What did they have in mind when they accepted this exception to freedom of navigation? Because this is what it is normally when we come to a contiguous zone. Third argument, there is no basis, and I quote, either in law or in state practice to give this term, sanitary, the expansive interpretation proposed by Colombia, end quote. So I am not sure what is the meaning of either in law, because it was a question of customary international law, but the court here took account of state practice and rejected it as not convincing because not large and contested. Also, perhaps it's even more interesting. The court had to apply the rules of Article 7 regarding straight baselines. And Article 7, again, reflects customary international law, and the court had to apply customary international law in this case. And here, the court did not take account at all of state practice, although this is typically a rule which is entailing an equilibrium between different interests, navigational interest and the interests of the coastal state, to have an internal waters and sort of security in their internal waters. And the court did not take account at all of state practice, even if we know that state practice, when it comes to straight baselines, is very flexible, very loose, if I may say. And even the practice of Colombia, which was claiming against Nicaragua's loose approach of the rules regarding straight baselines. So the court rejected that and focused really on the text of Article 7 and applied it restrictively. So what are the reasons for that? And I see two reasons. One is that the court had already interpreted this rule in a preceding case in saying explicitly that the rule should be applied restrictively. So the court said this customary international rule should be customarily applied restrictively. It cannot accept 20 years after to say, well, you can do it, whatever you want with it. So that was one reason, and I think it was the strongest reason. A second reason is that even if the state practice is widely flexible when it comes to straight baselines, as illustrated by an International Association report, there is always some protests by prominent states, including the United States. The United States is protesting each and every abusive law of the sea claim, and they are very much focusing on these straight baselines. And that could have played a role in the position of the court to disqualify the state practice to justify a flexible interpretation of the customary international law rule. So my take of this is that state practice is key. It should be a key element for the interpretation of customary international law rules of the law of the sea, reflecting an equilibrium, reflecting the point which is satisfactory after overlapping claims. It might be unclear. I mean, the rule can be unclear. The practice can be unclear and contested, but then it's up to the court, if it decides of the question, to appreciate the value of the practice. And here, of course, in the appreciation of the value of the practice, does it say something that helps interpretation? The judge has a margin of interpretation. That's something we cannot avoid. One protest will be sufficient or not to disqualify the practice, whether it's a big state, a small state. That would be up to the deliberation of the judges. But state practice has, in principle, a say in the interpretation of customary international law rules. Now, I turn to the interpretation of rules that are less the outcome of a compromise. And I said that these other rules are rather the expression of a sort of spontaneous belief or opinion that these rules correspond to a social need. So the origin of the rule, the reason, la raison d'être, as I said, of the rule is completely different. It's not sharing, it's not finding the equilibrium between claims, it's finding the right rule, what is necessary. It's completely different in terms of concept. And I mentioned environmental law, which of course includes the rules regarding the protection of and preservation of the marine environment. Of course, it entails, I mean, the UNCLOS refer implicitly at least to the customary international rules regarding the environment, including due diligence, the famous obligation of due diligence when it comes to protection and preservation of the marine environment. So how can we interpret this obligation, this due diligence obligation? I would just say, to finish quickly, that in a separate opinion, in a recent case, Costa Rica, Nicaragua, you mentioned that, Judge Donoghue expressed the view that the pulp mill's judgment was not convincing when it said that the due diligence obligation entails a requirement to undertake an environmental impact assessment. So the Judge Donoghue said, I'm not convinced by that. And she said so in regard to the state practice and opinio juris. So basically, she interpreted the principle, the rule, in light of opinio juris and state practice, not in light of any kind of social need, which will rather arguably the approach of the court in pulp mills. So I mentioned that because in my view, it shows the contrasts of the different approaches that you can have about the same rule, whether you will focus on practice and opinion juris, including post emergence of the rule, or you will ignore it to focus on the rule itself and to ask yourself, what is it made for? What is the object and purpose? I'm sorry to bring back this idea, but in my view, this is some kind of interesting path to explore, to consider that depending on the nature of the customary international rule, you would not be afraid of thinking of object and purpose. You would not be afraid of thinking of an interpretation which is perhaps, theological, which is the same, but also systemic, looking at the other rules. And you mentioned this realm of different standards, etc. That is the idea of a systemic approach of the interpretation. And that would permit to escape the sometime concerning state practice when it comes to the protection of the environment. So that was my small words.
Merci. Well, I think that's lots of food for thought from these three speakers who have given us lots of interesting ideas and I hope have given you lots of interesting questions. So who would like to kick off with the questions?
I would say it in Greek, but apparently Ilias won't be able to understand me. So thank you all for the wonderful presentations. I was planning on answering and questioning back Dr. Plakokefalos, but apparently the last few sentences of Professor Thouvenin basically answered the question. One extra comment that I would have, perhaps, because you said that you don't think that evolutive interpretation would be there. I would beg perhaps to differ, because you focus on practice there, on state practice, which is perfectly fine. But evolutive interpretation can have other venues there, which are not dependent on state practice. So you will have societal considerations, scientific, medical advancements, which would not qualify as state practice. So there, I think it might be a possible venue there. Otherwise, we're happy with teleological interpretation, systemic interpretation every time of the day. So my question to you is whether you think that that is a possibility or it is excluded as a method of evaluative interpretation. And my second question is to Professor Thouvenin with respect to the 2022 case, because you mentioned these two categories, the one where there is an equilibrium that is meant to be achieved. Because you refer to that, my question is, if I remember correctly, you mentioned that the court said that if we went that direction, the interpretation of Colombia, right? That this would essentially be contrary to the interests of the other state. Would you consider that this perhaps, especially considering that you're trying to achieve an equilibrium, that this was essentially an FAOT kind of argument for the customary rule, that if we go with your interpretation, we end up with a rule that doesn't make sense, basically? Yeah.
Thank you. I'm happy. Is this on? It is confusing. It is not, doesn't look like it's on the microphone. Okay. Okay, I'm happy to take a few other questions.
Thank you.
Nina.
I hope you can hear me well. So thank you all for the phenomenal presentations. As you may imagine, they put a lot of questions in my head, but I would like to focus on one in particular, mostly as I process through, and this is for Dr. Plakokefalos. In your presentation, you seem to treat the rule of prevention or the no harm rule as one customary rule, and then the rule on environmental impact assessment as a separate customary rule. So as two standalone customary rules. And I was wondering whether you believe that there is perhaps an alternative reading of what the court said in the cases that you cited, where these two rules are related to one another in the sense of general to particular. So that the rule on environmental impact assessment is simply a particular element of the more general rule of prevention. And then whether you think that perhaps this type of reading might allow for the analytical framework of interpretation that otherwise might not work. And why I ask this is because I believe that there is perhaps a possibility to read the relationship as, well, essentially the court said that an environmental impact assessment is a step in pursuance of prevention. So it is not a standalone obligation out there, but it is a sub-obligation of the bigger rule of prevention. So I just wanted to hear your thoughts on that. Thank you all.
Thank you. Any other questions? In the back?
Hello, we have some questions actually from the digital people here. I'll just read them out because this time they won't pop up. But actually, they both seem related to the question of baselines. So one is why the fixed baselines practice of small island states in Pacific, which is presented as a new interpretation of UNCLOS Article 5, but also an emerging customary rule has quickly become a widely accepted practice and not protested by many states. So that was one question. And the second one is, the second one seems to be two questions. So I'll read them and you can gauge if you how in depth you want to go. But it's, can the interpretation of the convention and the interpretation of customary law that is consistent with it be different? Especially when taking into account the importance of subsequent practice. Is it necessary for the ICJ or other courts or arbitral tribunals to consider interpreting treaties in such a way that their decisions do not contradict the majority of state practice? For example, in the application of straight baseline has generated little protest among states with the exception of the United States.
Well, thank you for giving us the questions from our friends who are with us on the screen. I'm now going to ask the members of the panel to respond to these questions. Where do we start with? Sorry.
Thank you very much for the questions. Some of my colleagues say, very interesting question. I will have to think of it and I come back to you in 1 year. But when it comes to the decision of the ICJ regarding the breadth of the contiguous zone up to 24 nautical miles and not beyond, I think that the underlying idea of the court is restrictive interpretation. Because the 24 nautical miles limit is the exact limit between the different claims, navigational rights and coastal states rights. To a certain extent, you could also say, I don't know if AUT would work, but you could also say that it's related to the object and purpose of the rule, which in fact, object and purpose is not different from normal understanding of the rule, except when it leads to say differently than what the rule says. And here it's exactly corresponding. The object and purpose is to allocate to each state what belongs to it precisely, and the line cannot move. I would say that's the rationale here. Restrictive interpretation, which is not inconsistent with object and purpose, because precisely the object and purpose is to set up the equilibrium between the opposing claims. I think that the second question was regarding the theory of, or I don't know if it's a theory, but the idea that the straight baselines of the state, which are based on the shape of the coast, will move, so withdraw towards the land with the rise of the sea. So that's the notion of ambulatory, I think it's the way you see it, ambulatory baseline. So the question is there a new customary international law according to which, looking at the practice of small states threatened by overwhelmed up by the water, is there a customary international practice saying that, oh, no, it's not, it cannot be ambulatory, it can be fixed once and forever when it is set up in maps. You know that the International Commission is working on that. And I say that every time. It's not because I'm not a member of the ILC. It's not that I'm jealous, but not at all.
It's dangerous to say that.
Well, this is because it can be considered as being somehow interested. I'm not. I'm just thinking that sometimes when you want to deal with codification, you must wait a little bit for the process to be achieved. If an institution like the ILC takes a question too early, it will generate a debate which will be perhaps a bit biased by politics. And if you look at the reactions of some states to the questionnaire of the ILC, well, I won't name any state, but if you take Russia, the commentaries of Russia to the questions are obviously politically oriented. My interest is to have the baselines ambulatory, because it will be, it will enlarge my margin of navigation. And I'm not sure that it's a good thing to, put in debate what should emerge from a practice based on an opinionaries gently. So I don't know if there is a new customary international law rule, but I think that we'll see what the ILC says at the end of the day. But again, I'm not sure it was a good idea. And the last question, well, it would be for next year.
Thank you. Yeah, it's for the speakers first.
No? Pano, yeah, I can see the point of evaluative interpretation, not including necessarily state practice, but including values or whatever, different things. I'm still not sure whether this is all a matter of nomenclature, in the sense that if we say that the content of the, that the identification of the content of the rule is interpretation, or the identification of the content of the rule is just stating what the rule is, just in customary law. It's just we're saying the same thing in a little bit different, wording, and the essence is the same. That I will have to think about, and we'll come back to you next year. Yeah, I can see the point. And I'm prepared to think about it in the context of these particular rules and what else could be there in the revolution, so to speak, outside state practice. Nina, yes. Yes, I mean, yes, it is environmental impact assessment. Okay.
Don't you prefer when you ask a question?
When I have, the obligation to prevent transboundary environmental harm is an obligation of conduct. This obligation of conduct is analyzed into obligations of result. These obligations of result, in my opinion, and we agree on this, are probably in that order: notification, environmental impact assessment, consultation and negotiation, monitoring, and so on and so forth. Now, it's not a matter of reading the case like that, because the case is not very clear. The case is, both cases, both Costa Rica and pulp mills, seem to imply that this is a separate thing. And they make a distinction between substance and process, even though then the distinction is being blurred in practice. So you can read it like that. I don't think that this is how it is meant, how the court saw it. I'm not convinced. But in essence, of course, we agree. Yeah, no doubt.
Do you want to respond to any of the questions that have been asked?
Yeah, I don't think any was addressed to me, so.
But feel free to
Jump in.
All right, if not, are there any further questions, including questions for Professor Morgera? Two questions. I see two questions here, and the microphone, that's good.
Hi, I have a bit of an overarching question. It seems that we're all relying a lot on judgments and what the court has said. And I'm just wondering, what do you think that the importance of these judgments are, especially since we are all kind of in agreement that they're not very clear? So why do we just try to kind of like find things and answers into these judgments? Do you, especially since we are in the presence of judges, I was just wondering, do you have any comments on what is really like the place and the authority that we should put to this kind of judgments in our scholarship?
This is what I was asked to do. No, literally. No, it was like a...
Thank you very much. My question shows my ignorance, but it is an issue that is becoming very, very important in the WTO now world. Jean-Marc spoke about the fact that, if I understood correctly, they're often in opposition from one or two to state practice or subsequent practice. My question is simply, is it conceivable to have regional practice or regional sub-practice by a subgroup? Because just to link it back, in WTO, negotiations are difficult, and in 8 areas, subgroup of members have said, we go ahead. And the big question that is a bit on the legal desk is, what's this animal, these subgroup agreements that are not envisaged? So I wonder whether the concept of customary law is exclusively universal, or whether we can think of regional subsequent practice or state practice.
Thank you. And then I think the final a question is from Celine.
Thank you. Celine Trevisan at University of Utrecht. I have quite a bit of pressure now as her last question. But it's actually, it links to some previous questions also. So, and it's a bit for all panelists, but it starts from what at the beginning of the presentation of Ilias, who said, wanted to flesh out a bit the specificities of environmental law, but then you left them out in a way in your interpretation of how custom is also identified and in a way interpreted, or both take it as you want. So maybe more of a reflection on that. How do you see actually those specificities, in particular with the institutional arrangements, which are so characteristics of environmental law and which are having quite an impact in the development and the way in which also state practice is evolving in interpreting and applying those rules. And then that links a bit also to the presentation of Elisa on this need of transformative change, and how do you see the role of those institutional arrangements in pushing that agenda, working with, of course, what we have? Thank you.
Oh, yes. But that is truly the last question.
So my question is for Elisa mainly, and I kind of piggyback on the previous point. So I understand that part of the project is the idea of using networks of NGOs, of non-state actors, of what might be, of entities which we have not associated with law creation. And I was wondering whether the language and the framework of interpretation, like saying what I've been doing is I'm interpreting customary international law. What I've been doing is I'm interpreting treaties, could be an effective way in order to gain access to the closed club of creating law, of bringing about transformative change.
Thank you. So I'm going to ask the three participants to answer the questions that they think are interesting to answer. No, without joking, but let me, maybe you could start?
Ah, sure. About courts, Anna, really, this is, I just focused there because this is what I was asked to do. I was not joking, right? Might be funny, but I wasn't joking. Celine, this is exactly what I had in mind when I was saying that there might be some sort of intermediate step, or if you look, the identification of the content of the rule as interpretation, conference of the parties, meeting of the parties, you know, all these bodies that produce immense volumes of material every year, you know, under a fairly large number of conventions, and they shouldn't be flying under the radar of the International Court of Justice, at least when it once in 5 or 6 or 7 or 10 years gets to decide a case that has to do with international environmental law. I agree, and it might be exactly that that they should do. Whether they're going to go into that, you know, down that road, I sincerely doubt. I think they won't. Much in the same way that you don't see very often a very clear expose of the methodology and the rationale of looking at state practice and opinio juris. You just have a phrase that says this is part of general international law. I don't know, but I fully agree. It needs to be taken into account because it is both normatively valuable and and of practical importance, right?
Just say it was worth the wait for my question. Thank you all so much. And I'll try and answer the last 3 questions together, but it's true. Actually coming here, I was a bit nervous, but thankfully I wasn't given a specific brief. So I felt I could take the liberty to look at interpretation, I guess, elsewhere than in the judiciary. And I mean, through my professional life, I've been very interested in interpretation as part of progressive development of international law, interpretation as discussed in international soft and hard lawmaking processes, but also interpretation by UN bodies as advisory bodies in advising on what's maybe in a more unthreatening way called, you know, good guidance, good practice guidance on developing national laws, on developing means of implementation at the national level. But all of that is very much interpretation, and we can discuss whether or not that may be more effective or, you know, have different entry points in influencing state practice and state conduct. And I think what I find interesting in that work is exactly the point that was mentioned by Panos around bringing the evolutive interpretation on the basis of real life experience, scientific evidence, and other kind of evidence that tells us both about the effectiveness or not of what states are doing in implementing or not international law, but also what we as the ultimate beneficiaries of international law implementation are learning, or how we've been negatively affected by that maybe insufficient state conduct. And that, I think, leads me then to my project and the question you were asking. I mean, we are a network. Actually, what we were mandated by our funder to be was create fair partnerships between people at different scales, from the local level, human rights holders who are left out of decisions basically all their lives, and in fact through generations, to the legal council at FAO or UN special rapporteurs. And the interesting thing about that being having a fair partnership mandate is that, first of all, we need to work together. So we have to find a shared agenda, something that brings us together in engaging, well, in our case, legal interpretation. And it has to be fair. So what that has meant is understanding what each of our needs were, and then finding a way through the insights into equity to then make propositions that we're bringing together the science, we're bringing together social needs as expressed and not met by governments, and the insights from actors working at the international level, regional level, and transnationally. And in effect, I think we have been through a process of inter and transdisciplinary legal interpretation. So some of the ideas I shared today are really coming from that dialogue over 4 years of understanding what we need at the very local level and what UN partners have seen as missing and being a barrier to achieving international objectives because of how states take or interpret very restrictively and conservatively their international obligations. And that also has given me I think an insight around what you were asking about what kind of international institutional arrangements we need, which may nurture that kind of transformative dialogue. And I think all the people involved in my project have felt a sense of transformation. I feel transformed since I've started this project, for better or worse. But I think what I've been thinking more and more is about how creating multilateral fora where we can have that learning dialogue, a dialogue between human rights holders, human rights defenders, experts, and scientists from the natural and the social sciences, to understand that all the different sides to equity in a particular global environmental challenge, and work together a solution that would be acceptable considering all their respective roles, and then offering that to states. And so in a way, how I see it, and I've been suggesting it for the BBNJ agreement, I've recently been discussing with the WHO about their proposed pandemic treaty. It could be, something as simple and common as an advisory body who contributes to regular monitoring and review of a treaty implementation, but is really meant to be a space for open dialogue and systematic dialogue about the equities and inequities and what different actors feel is needed to overcome those inequities. And then for those actors, which I may also be at the extreme sides of the debate, to say, well, is there something that can work on the basis of this understanding to move forward? And then offer that to states for states to decide, but not expecting state representatives to be able to relate to all those experiences out there, to all that knowledge, and figure it out in the usual treaty mechanisms we know.
Thank you. So why do we care about judgments? Basically, that's what you say. And judges could say, and I heard one say that in the American Society of International Law, a former judge, who say, who cares about academics? So more seriously, the question is, who can resolve disputes? And then you have quite a quick answer, judges. You can have resolution of dispute by negotiation, by other sort of dispute resolution. But if it doesn't work, you have judges. Not always, sometimes. So I think it's a good thing. And looking at what they do can be, quite, to me, it's a miracle. We inherit from a huge work of our predecessors to create this path, possibility to go to judges, to have resolution of dispute. And I think we must preserve that rather than, break it by saying it's rubbish. The second thing is, who complains about the manner judges see Customary International? Well, sometimes you have complaints, not that much. Well, UT possibilities, who demonstrate the existence of UT possibilities? Is it a good thing? Well, yes. Does it work? Well, it can. Some states complain, one of my clients does, of what the court says about customary international law, but in general it works. So I think that taking into account what the judges do can make sense. We can comment, say it's not convincing, perhaps judges listen, read, and improve. And I think that's the dialogue that could exist between the judges and the academics. We should care about academics, and academics should care about judges, rather than say who cares about each other. When it comes to the question of regional custom, so I don't know, really, I cannot tell you anything about the GATT and the WTO, how it works when it comes to regional custom, but of course it exists. We have different cases, including right of passage in Indian territory as well, in which you have kind of a explanation of what can be a bilateral custom. Well, when it comes to the law of the sea, which was my topic, it's more complicated. You might perhaps have something regional in a closed or semi-enclosed sea, might be like in the Caribbean, for example, but as a matter of concept, the law of the sea concerns every state, and it's difficult to isolate a region which a peculiar kind of bunch of interests regarding a part of the sea. Perhaps the Azov Sea could be a special feature. Caribbean Sea, why not? In terms of protection of the environment, you can have something, and other, well, some paths are existing.
Thank you. Just two final comments from me. I think it's important on the one hand side to keep in mind that states are likely to not speak about what they specifically consider to be rules of customary law in general. States will only do that when it's necessary. And then they will investigate what did we find as practice, what did we find as opinio juris. If there is no need, shut up. This is the general mindset of government lawyers. With respect to judges, well, apart of course from Professor Thouvenin being my lifelong friend from now on, I also would say that the complaints about judges not demonstrating the very detail of the interpretation of the law they found, apart from that, I think it's important to keep in mind that although academics would want to find an academic analysis of every step of the process of the creation of a customary law rule, we know all the steps that it takes to get to a treaty text. So our audience, particularly our academic audience, would want to know, how did a particular court or tribunal come to that conclusion? Whereas from my experience in practice is, well, of course, everything has to be properly motivated, but the goal that the judges see for themselves is to find an appropriate solution within the law. The goal is not, let's go to the detail as to how this rule formed. It's necessary to indicate that, but we'll not get into the detail of that, because that was the idea that the academics would do that. Anyway, with those thoughts, I would like to thank my three colleagues here. It's been an interesting discussion, and I think it's now time for tea. Thank you.